call. Chester Borrows.
Thank you, Mr Speaker. The Child and Family Protection Bill is a bill that enjoyed good and wide discussion and debate and no small degree of consensus when it came before the Justice and Electoral Committee. And of course, as the senior member of the House calls, he would hope so. And there's no real surprise there, because a large number of the clauses within that bill had initially been raised under the previous government and under previous legislation. And so really the discrepancy between the two sides, government and opposition parties, in respect of this bill really just remain around the age 17 and whether or not the default position should be that any protection order that is in vogue at the time should continue even if that person moves away from home. I guess the arguments that ran against it, seeing us in a slightly polarised position, and that the government position remains that when the person over the age of 17 who as a child was a subject of the protection order moves away from home on a permanent basis, then it will lapse. But while they are living at home either permanently or semi-permanently, then it remains in vogue, so it remains valid. And so what that means is this: the young person who is covered by the protection order turns the age of 17 and goes away to university, but comes home and lives there in the holidays, lives back in their family home in the holidays, continues to be covered. Similarly, for instance, if they were working away from home but spending the weekends back in their home, they would continue to be covered. And it would be covered indefinitely for as long as they continued living in that home. The problem that we have is that when you consider the other side of these sorts of disputes, that a protection order may well be taken out obviously legitimately and obtained through the normal course of proceedings through the family court. It's instilled. Frequently, the children of the household have no say on whether or not the protection order is taken out, and gradually over time the need for that protection order may dissipate somewhat. If that young person leaves home 18 or 19 years of age and goes and lives sets up in another relationship, or goes away for education and lives permanently somewhere else, or goes away from work, if you didn't have a position where it lapsed, there would be prevented for the estranged parent ever having any contact, making any contact by way of email, by way of telephone, by way of letter or visit or anything else, and prevents the possibility of a relationship occurring, because any contact is a breach of that order and can be the subject of a complaint. And it is around about that time when a young person leaves home and establishes themselves independently from their family and sets up their own home, that they may well want to explore that relationship again. And if it continued, the law would prevent that happening. And we have to remember the young person under the opposition's suggestion would be able to withdraw from the protection order. That's quite right. But at the same time, we also know that young people frequently don't pay attention to those sorts of things that impact on their lives. And also, if, for instance, that the protection order was taken out when the child was, say, a 7 or 8 year old, 10 or 15 years later, they may well be in a different space where they want to have some contact, but at the same time they're in their naivety, not withdrawing from that protection order may well mean that any contact that's had by, say, a father who wants to regain the relationship could mean that they are committing an offence by establishing that contact. And a younger person who's in their sort of early 20s or whatever is probably in a much better position to be able to access protection if they need it, access the assistance of the authorities if they felt threatened or they needed it. And so the government believes that a person of that age is in the right sort of position and maturity to be able to pull away from that protection order or to reinstate that protection order should they desire to do so. In respect of other matters raised by the previous speaker, it's important to remember that the bills that were introduced by the previous government were done very, very late in the proceedings. The SIFS Bill number 6, which was nominated, for instance, was tabled in the House 2 weeks before the last government rose, and had sat there for a number of months without any implementation. We have to remember too that in the context of running up to the last election, the previous government was involved in a number of other things which in hindsight do not appear to have been urgent legislation, and if the child protection was at the forefront of their minds, they could have done a lot more about invoking that legislation at that time. They can take some heart from the fact that the Minister of Justice has taken on a number of their recommendations and has put it into legislation. This particular bill, for instance, was the subject of some debate when the short-term protection orders, or the police safety orders as they are now known, was being discussed under the legislation that came out of the 100-day plan in the first year of this government. And at that time, when the Select Committee raised with the Minister the concerns they had around the need for legislation in this bill, the Minister undertook that it would be introduced within a year and would come back before the Select Committee. So I'm pleased to commend this bill to the House. I'm pleased that it receives wide support from all parties, and we look forward to further introductions of more child protection measures in due course, and no doubt they will come.